The pleas that were entertained today, a notice has been sent to the Gujarat government. But when you just look at the pleas in general, when it comes down to the, just the pleas in particular, many suggest that they are weak, that, 2 weeks from now they won't be able to stand in court.
Whether the petitions would finally stand to get any relief or not, on what count they would not be able to get, I do not know, that is something time would tell. But the fact that people have come, challenged that remission order, conveyed it loudly to Bilkis that you are not alone, we are there and we can take up the cause. I refuse to accept that argument of no locus, each one of has the locus in this particular case. That technical argument of criminal case, strangers and all that, I'm not really getting into it. But as on date, I'm very happy that Supreme Court has taken cognizance, issued notice. The Council for the Convicts raised the preliminary objections. Court for today ignored that. What happens in subsequent hearings is something we have to see then. But today, as far as today is concerned, it's a good move, good progress, good development in the matter.
I'm going to come back to you, Ms. Gupta, on what would be Bilkis Bano's stand from here on, but I want to cut across to Rishi Malhotra. Rishi Malhotra, a lot of objections that was raised from the convicts part were not entertained in court today, but yes, the 11 convicts have been, now the plea will have to include the 11 convicts as well.
You see, there were threefold preliminary objections which we sought to raise. One was that there was no locus standi of a political outfit to challenge any remission order, because the criminal law jurisprudence categorically states that there are no third party or strangers which are allowed to perpetuate a criminal litigation. Of course, had the victim or the complainant or the state or the center, if they would have come, certainly the things could have been different.
But with PILs,
but certainly a stranger to a litigation is not permitted.
We'll go one by one. Mr. Malhotra, we'll go one by one, if you don't mind. Number one, the locus standard that has been challenged. If somebody is aggrieved, then they are well within their rights to lodge a PIL. What's wrong with that?
That somebody has to be a person related to a crime. He may be a victim, he may be a complainant. But it can't be a roadsider or a stranger who just walks in the court and says that, no, I am aggrieved by a High Court order or I am aggrieved by an X order. I should be permitted to challenge in Supreme Court. I'm sorry, that's not the law in Supreme Court since 1992. A similar circumstances, Simranjit Singh Maan case was dealt by Supreme Court, where an Akali Dal MLA filed a petition in Supreme Court under Article 32 challenging the conviction of the murderers of General J.N. Vaidya. And the Supreme Court knocked that petition only on the ground of locus standi. Since 92 till 2013, when Subramanian Swamy filed a public interest litigation against that Nirbhaya juvenile case, the Supreme Court reiterated the law and again knocked out that petition on the ground of locus standi. So it's nothing new.
Okay.
And I would say with greatest of respect that if the Supreme Court interferes and entertains this writ petition, this will be acting contrary to a settled law and settled principle.